employees and the KRS system, or the employees and the state of Kentucky. There's a process there, and some of that could be hashed out in court. You know, we need to know who the parties are. I can tell you this, that I started in the CERS system as a firefighter in 1988, literally a few months after the state passed a law that said that municipalities must move their pension systems into the KRS system. And I, at that time, was hired, and I knew what I was getting into. I didn't have a choice. But prior to January 1st of 1988, the employees who were part of municipal pension systems did have a choice. They could stay with their municipal pension system, or they could go into the KRS system through CERS. That was an important choice, I think, that was given at that time. When we talk about pension systems, I think people know that we're talking about state-created entities. So there is no Supreme Court cases necessarily on inviolable contract related to state pensions. We haven't got there yet. But many states deal with this through their own constitutions or their own state laws, and some refer primarily on the federal constitution of non-impairment of contracts. And of course, Kentucky has the same language that you cannot impair a contract. So it's important to know who the parties are in the contract. Now, it's also known that not all states, or some states, have allowed their employer groups to get out of their pension systems. But it's also important to know that of the 37 states that there have been some decision on that, 21 of the constitutions have been ruled to say you cannot reduce the future accrual of benefits. 16 have not said that. They have said they either have it in their state constitution that the state legislator makes the laws related to the future accrual of benefits, or that the courts have determined through their own state laws that they can read that state legislators can affect the accrual of future benefits. But Kentucky's constitution and its own inviolable contract language that's already exists in the law makes it very likely to be a challenge here, and that's the important part. I mean, there are many important parts of this. There's the moral obligation we have to these employees, but this important part is this challenge that's likely to happen. And this will get into a little bit the KBA situation here that the gentleman from Jefferson spoke on. But the challenge here, we're not talking about an injunction that just ends puts a stop to the law, it doesn't go into effect, and not a lot of dollars. We're talking about whether at what point, perhaps thousands of employees at some time in the future, not just today, will challenge this law. By that time, we could be talking about tens, if not hundreds of millions of dollars being affected by us not permitting employee choice when it comes to these Tier 1 and Tier 2 employees. I have a major concern about that. You know, I think it's interesting that the KBA situation did come up. I really wasn't going to speak on it, but it's important to know, and what I said in the state committees in the hearing was that this wasn't an adjudication of the law. There weren't briefs to be filed. There wasn't a case of controversy. This was the Supreme Court acting administratively to carry out its duties to the KBA, which of course is an arm of the Supreme Court. But there is no case pending. There is no, as I said, nobody has filed suit over this situation yet. But I did look into the Kentucky Code on Judicial Conduct. And there is a rule, it's Rule 2.10, Judicial Statements on Pending and Impending Cases. And the gentleman from Jefferson did point out that this is something that is right now a hot topic and perhaps something that might be impending. The rule says, a judge shall not make any public statement that might reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court, and make any non-public statement that might substantially interfere with a fair trial or hearing. Now, in the comments, and I think the attorneys in the room will know that when you study the rules and the ethics and the codes, the comments are important. And the first comment is the most important. And the first words in the comments section on that particular rule says, this rule's restrictions on judicial speech are essential to the maintenance of the independence, integrity, and impartiality of the judiciary. So I think it's pretty important to note here that we are not talking about a ruling, a case. We're talking about the administrative decision of the KBA during this time. And there are laws on the books, and the laws on the books allow for the cessation of employers from the pension system, and the KBA took the proper role, took the proper steps to make this happen. But there wasn't a case in controversy. This was an administrative action. This was an action, of course the judges are supposed to follow the laws. And they've not had this case in controversy, so there was no decision made here. And I don't mean to be flippant about this, but you know, there are plenty of laws that could possibly come before the Supreme Court. They may not be impending as this particular consideration of this law is, but imagine back when we passed the helmet law for motorcycles, and they said that, you know, you're no longer required to wear a helmet when you're riding a motorcycle. And a Supreme Court justice rides down the road on the motorcycle without a helmet on. Is that his statement that this is constitutionally protected action, speech? I don't think so. So, Mr. Speaker, I would just want to further say that a defined benefit pension, which is what I'm fortunate enough to have, and I think some other members on this body has, provides a certain security that is missing in this whole country, to be honest. And while we used to have defined benefit pension systems throughout the state, throughout the country, in the private sector, we don't as much. We still have 11% of the private sector has a defined benefit pension available to them. And understand, too, that there was this is a Wall Street Journal article in December of 2018 that said the number one desired benefit of any position in the private sector still is not health care coverage. It's a defined benefit pension. And I believe we have a moral obligation to keep this option available to our Tier 1 and Tier 2 employees, not only as it exists in this particular bill, but for any future cessations from the pension system. With that, Mr. Speaker, I'll have one more question for the sponsor.
He will yield another question.
Thank you. Gentleman from Spencer, you didn't talk about defined benefit very much in your description of the bill, but there are 4 mentions of it in this legislation, proposed legislation, and it says that no entity that exits a system can go to a defined benefit system, when I think we all know, or it's been commonly known, that some of the entities that have left the system have created defined benefit pension systems. And I'm wondering why we are specifically excluding defined benefit systems for anybody who wishes to cease from the pension system.
Gentleman from Spencer.
Thank you, Mr. Speaker. Gentleman from Kenton. That language is in the bill. I believe, I don't have that particular section in front of me right now, but if memory serves me correct, it answers that question because of the increased cost to the employer.
So the employer doesn't have, I'm sorry, just if I can clarify.
Gentleman from Kenton.
the increased costs to the employer if they exit the system and they were to create a defined benefit system, we are saying we're directing these employers not to have a defined benefit system because it's going to cost them too much. We're telling them you can't have a defined benefit system, it's going to cost you too much.
Gentleman from Spencer.
Gentleman from Kenton, these agencies are at catastrophic situation with their unfunded liability. That group that I mentioned a while ago, that's down to 3 employees, their unfunded liability is $55 million. I don't know how they're going to pay that off with 3 employees. We have a situation here that is financially impossible, almost financially impossible. That language is inserted to try and give them the best possible opportunity to make it through this. It is very likely that some of these entities, even if they make choices, they may not survive. I'm aware of that. So we're trying to give them every possible avenue, and that's the reason that particular portion was added to the bill.
Gentleman from Kenton.
Thank you for that, gentleman from Spencer. And to finish my comments, I would say the answer that was just given is a further restriction and less options. You know, if they want to attract the best employees, they might want to offer a defined benefit system. And so we are creating an option for them that limits, you know, how they might attract the best employees. And I don't agree with that. So just to sum up, I have moral issues with us taking the Tier 1 and Tier 2 employees and telling them that they can no longer accrue future benefits based on impairment of the inviolable contract. I have a problem with the call itself and its restrictiveness and not being a severability clause here, that we have no opportunity to make any changes to this particular bill. There are many good ideas out there, and I think both sides of the aisle would have perhaps presented some, but with this restrictive of a call, our hands are tied. You know, and I know that's frustrating for a lot of us. It's particularly frustrating to the minority party. With that, Mr. Speaker, I'll yield. Thank you.